discussing and exploring how India's important point, which I am just mentioning, long and underutilized class action mechanism is emerging as a powerful instrument to strengthen corporate governance and protect investors' rights. Now, why I'm saying long underutilized class action suit? Because it has come long back with the Companies Act 2013, but rules and other thing has laid down later on, and there was no earlier case in India. So that's why this particular case, which is discussed in NCLT, is taking prominence. The NCLT admitted class action suit against the Jindal Poly company, which was initiated by minority shareholder. And the minority shareholder was alleging that the company has significantly value transfer through related party, represent a watersheded moment of this particular minority shareholder when they have raised this particular issue. And it is coming out like a minority shareholder actives in the corporate world in a big way. The session of today's will unpack the legal issues of Section 245, analyze the governance imperative, and what NCLT has given its ruling, what point has discussed by both the parties, and the implication for this board, regulator, legal practitioner, and investor after this particular case. So today we want to discuss in this webinar the legal framework of Section 245, anatomy of this particular case of Jindal Poly, governance and investor protection imperative, practical litigation dynamics, precedent value and future outlook, role of board, role of professional, including auditor and consultant, and all these points we will discuss in detail. So now we have invited the esteemed panelists and from different field. We have today ex-tribunal member of NCLT. We have a proxy advisory head, Mr. Jain Gupta. We have practitioner, Mr. G.P. Madan and Ravi Prakash. And all will discuss about the various aspects. So first, I welcome Mr. P.S.N. Prasad, who is today's our guest of honor. He is senior legal professional, over 30 years of experience across judicial, regulatory, and corporate dominance. A former judicial member of NCLT from 2019 to 2024. He has adjudicated matters under the IBC Companies Act. He previously served as a senior legal roles at Reserve Bank of India, HUDCO, 63 Moon Technology. Currently, he is a principal legal consultant and advocate in Mercury Law, Hermitage, specializing in corporate law, arbitration, banking law, and regulatory compliances. I welcome Prasad sir. Your experience will definitely help all the participants today to understand this concept and to see this, that how the new concept which is emerging, how it will take impact the governance in India. Welcome, sir. Then we have our other next speaker, Mr. Jain. Thank you, sir. Thank you. Then we have Mr. Jain Gupta. He's a seasoned capital market and corporate governance professional with over 4 decades of experience across regulation, industry, and finance. He's founder and managing director of Stakeholders Empowerment Service, SES, the non-profit organization dedicated to strengthening corporate governance and shareholders' right. A complete fit topic for Mr. Gupta relating to this, for which he is advocating since long. A former executive director at SEBI, he led key functions including market regulation, surveillance, derivatives, and served as a member secretary to the Bimal Jalan Committee. His earlier role including senior leadership position at Grasim India, Ocean Oil UK Limited, and State Bank and BHEL. I welcome Gupta sir for this webinar, and your word of wisdom, your experience, your insight will helpful to uncode this particular concept of class action suit. Then we have Mr. G.P. Madan. He's a founder managing partner of Madan Law Office, and he has over 3 years, 3-decade experience of corporate legal, litigation, governance, and capital market insolvency. He has served as a chairman of ICSI and IRC, co-chair of ASSOCHAM National Council of M&A, and he is associated with NCLT IBC Committee of PhD. So I welcome Madan sir. He's just joining. He's in the court, NCLT. He's coming shortly. Then we have Mr. Ravi Prakash, Associate Partner, Security Law, Corporate Litigation, Corporate Professional. So friends, this is our panel today, and you can see the multiple people are there, multiple experience and multiple field. So before starting this topic and handing over to Prasad sir, I just want to give a brief point relating to this topic, that why we have selected, what are the urgency, what is happening. So everybody should understand this is not a litigation topic. It is a governance reset mechanism, because something which is already there, nobody has talked. Now it is reset mechanism is taking place. India has had Section 245 for years, but it remained underutilized or unused. Now we have a fresh spark. The NCLT has admitted a shareholders class action in Jindal Poly, and the admission itself signals that the provision is ready to be operationalized seriously. Because in this particular case, lots of issues relating to validity, challenge, procedural, the international law, everything is discussed in this. When class action activity activate, board do not face to case when they face collective scrutiny. Because in this class action suit, the interesting part is that it is not that it is one of the case. This particular thing is for the board. They are facing collective scrutiny of their decision-making power, especially when allegation involving RPT and value transfer. That is biggest challenge for the board. So core purpose in simple word, if I can just say, individual investors are often too small to fight large governance failure. Regulator cannot policing every transaction real time. So law creates a collective action lever. If a threshold of shareholders comes together, the system listens. That is the main part. Now the question is, not every bad governance action is a fraud, but some action can still cause systematic value erosion, particularly via RPT, group structure, asset transfer, selective benefit, effect disclosure, and minority shareholders need a mechanism stronger than isolated complaint. So many shareholders are making complaint, but that complaint is nobody listen. But if you are going collectively, then then the court and the regulator listen properly. That's why this particular law has emerged. Now in NCLT order dated 5th February 2026 on this, Jindal Poly rejected the company's maintainability challenge and formed a prima facie opinion that proceeding under 245, and admitted the petition to the extent of issuing notice and directing public notice to other shareholders member as per NCLT rules, which is there. Now, reportedly threshold is around 5%, and shareholders, those who were filed the case, that were 4.99. Public reporting also notes the company's stance that the admission is on maintainability threshold and not on merits. Now, one of the key discussion emerging out from the order in the tribunal, the willingness to treat Section 245 is not limited to only preventive relief, and to consider that it can extend to past concluded transaction. A common defense, it is old, so it is not maintainable. Because in this case, the appellant has asked this particular thing, that it is a past issue and there's a penalty, so you cannot raise this particular point, and this particular class action suit is talking about the preventive. So that's why it's not maintainable. So if in the court order, if Section 245 is read narrowly, it becomes toothless. If read functionally, then it becomes serious governance tool. This order indicates a move towards the functional reading while still leaving merits of this particular trial. And friends, in the global reality also, class action are mainstream in many markets. US market is prevalent, and there are so many people are doing class action. And some of the Indian companies also class action suit has faced. In 2025, disclosure dollar loss in US securities class action suit were reportedly around $694 billion, indicating the scale of alleged market impact even if filings fluctuate. So why it is work globally for successfully, and in India it is not yet started, and it is a baby step. The plaintiff law firm, there are so many firms, they are the act as a plaintiff and the representative of plaintiffs. In India, you can't do this because you can't share fees, and there they charge on the basis of that whatever we'll get, we'll share. Institutional investor is stepping up. Discovery, the settlement framework and claim administration is there. Litigation finance and subjurisdiction is there. So people, those who have no fund, they can get, and they can share that fees. A strong disclosure, continuous disclosure obligation, that is there. That's why in global market it is taking place. Now for board and management, now there's a very important part. Higher scrutiny on RPT governance, audit committee process, fairness opinion, valuation, rational, disclosure, quality, absenteeism of interested party, and documented alternatives. Here in the board, expect sharper focus on process integrity, because in this particular thing, how the board process is taking place, board is discussing or not, they are taking part or not, how they are monetizing, independent director, what they are doing, audit trail, internal control, all these things will be now a very, very big challenge for independent directors. Reputation and market perception. Now the problem is that for all companies, even admission stage development can trigger sentiment and volatility, and public reporting indicate the company has argued the share price was impacted, and share price is definitely impacting on this. For professional, in 245 1G 2 and 3 point 2 and 3, they are including auditor, they are including expert, they are including advisor, they are including consultant. So if these people are giving wrong information, which is converting to identified as a fraud, then they are also responsible and they have to pay. So whatever fees you have taken 5 lakh, 10 lakh, 20 lakh rupees fees, but the penalty can be 10 crore, 15 crore also on the basis of loss. So by your one document can create a problem like this. For investor, proxy advisor and activist ecosystem, what will happen? Proxy advisor may build section 245 as a risk flag into voting recommendation, RPT intensity, board independence, auditor challenge, qualified opinions, and promoters conflict. They will include. Institutional investor may become more willing to coordinate with they see an actual admission precedent, and they can become the party to this. For regulatory and policy, the case will likely pressure the system to clarify threshold, notice mechanism, good faith test, cost scrutiny, damage quantifiable, and transactions and interaction with SEBI's regime for listed company, and the concept of derivative doctrine also, which is in USA, and in this case also discussed, that will also come. So friends, whether it's a company board, whether it's a regulator, whether it's a professional, whether it's a investor proxy advisory, everybody has to do something. Everybody has to realize that this particular class action will be one additional mechanism where people are watching. Only concern is, which has come into this case also, that there is a separate section 244 operation mismanagement, where here they are talking about the 5% and 2%, and in 244 they are talking about the 10% and 100 members. So that time And in this case also, they raise this issue that this case is not class action, it's a operation mismanagement case. So these things and these clarification are required, because here the law says, rule says 5%, and the operation mismanagement 244 says 10%. So this issue will also come, and there will be test whether it's a operation or it's a class action. Now, to remove these doubts, to understand the concept in the future and what will be the impact of this, we have to listen to our expert. Now I will invite Dr. P.S.N. Prasad sir. I know you were busy, but you have accepted our invitation and you are ready to speak on the move. So over to you, sir, on the topic. Thank you very much. Sir, you have to unmute, please. Prasad sir. Unmute yourself, sir.
Good evening to everyone.
Good evening,
Am
sir.
I clear?
Yeah, good evening.
Yeah. See, we have to understand section 245 from two angles. One is it no doubt protects the investors' investment protection. Secondly, it also strengthens the corporate governance. This 245 is put in such a way that more onus is there on the adjudicating the so-called adjudicating authority or the NCLT first to arrive at a conclusion whether 245 is applicable in the given facts and circumstances of the case. So there are certain key parameters that need to be satisfied beyond doubt. Then only one can look into 245. Those were specified in class 4 and 5. And when we look into this, once we satisfy the criteria, then there is a scope for voice of class action. And this class action is, as our brother Praveen Kumar has said, it is new to us, and it has, though it was there in the enactment, it has come into force from the year 2016, and first time it has come into light in this 2026. But when we take this 245 vis-a-vis the other provisions in the same chapter, what we have to appreciate is the remedies that are provided are more stringent in nature under 245 when compared with oppression and mismanagement provisions. And there and here the advantage is that one can continue to be in the process, or one can go as opt out also. Opt in and opt out concept has also been introduced in between. Therefore, 245 has to be very sparingly used, because this is a draconian provision. In a way, this is a draconian provision. If we don't appreciate the circumstances under which the action can lie, the petition ought to be dismissed unless the criteria that is required and specified under this section have been fulfilled in toto, both to the satisfaction and there is a failure of business, there is a failure of chance of business in future, then it can definitely invoke 245. This is my first view. Next is the 245 now, which has been seen its light in this case, is going to now another application is also been filed in NCLT. This has created now a starting movement, and this movement ties and binds every stakeholder in the process of the company business. He may be an auditor, he may be uh, a consultant, and he may be an advisor, whatever capacity he is, or he may be a key managerial person. All should be aware, and um, they should take enough due diligence precautions while suggesting any action, including on the board as well as out of the board. And every action should be established automatically itself. It has been done in the best interest of the management of the company. The moment, see, in the recent case, it is a kind of relative transfer of properties transfer to the relatives, and that has created the whole issue. In fact, now I am traveling from Amravati. So, talking on this point, the 245 is placed in a different footing when compared with the other provisions of oppression and mismanagement. But the spirit of oppression and mismanagement can also form a kind of guiding principle for establishing the criteria laid down under 245. Therefore, never, generally, the bench which is deciding the matter under 245 will not only strictly look into 245, it will also look into the scope of the oppression and mismanagement, and oppression and mismanagement provisions have also been a kind of paving way for establishing the criteria laid down under 245. So these things have to be seen, and the applicant have to establish beyond doubt with adequate documentary support in order to get notice of admission itself. So, from the judicial point of view, the application, the moment application is filed, it will not be entertained. It undergoes a lot of scrutiny, and it undergoes lot of study from the bench itself. The members, both the judicial and technical members, will go in deep in understanding the pleadings vis-a-vis the strength of the documentary support. Only with the strength of the documentary support, the pleadings will be accepted. If pleading is made, documentary support is not there, then such pleading cannot be honored, and it cannot lead to the issuance of notice. Therefore, very important is, while structuring the matter itself, one has to collect sufficient documentary evidence which can speak about the satisfaction of the ingredients laid down under 245. See, actually, the spirit of this earlier has come for our consideration when I was dealing with the depositors' cases of Unitech. We have examined a lot of things, whether to identify there is a mismanagement on part of the company in returning the deposits to the depositors. So, at that time itself, the parameters of 245 have been slightly indirectly applied. But now, since the class action has seen its light from 2016, there is now a large scope for looking into the each and every aspect of the class action, and also this criteria for class action is that the number magic has been given no importance. In a way, this judgment says whether the class, though the class is not fully strengthened, class is less in number, whether they could raise their voice in a proper way or not. that has been seen in the application is concerned. And in fact, to put little more, uh, the when this matter was filed in 2018 and 19, we had first discussion. At that time, I was there. We have had a discussion, and we thought that each and every ingredient have to be undoubtedly satisfied what is required under the section. So a lot of scrutiny went, and finally it is good that it has seen the light of the day. But still now this decision has been appealed. That means the notice, giving notice has been appealed before the NCLAT, and NCLAT is yet to give its finding. NCLAT has heard on day-to-day basis almost all, and still NCLAT has to uh, give its views and findings. 245, in fact, has now opened a new window for professionals, and as well as it is a kind of hint that those stakeholders who are interested in the well-being of the company have to gear up themselves in whatever capacity they are, either as a professional advisors or as a member of the board. Wherever they are, they have to see nothing else than the best interest of the company. The moment scale has been slightly deviated from the concept of best interest, then 245 will automatically get attracted. In the days to come, so many applications of 245 will be filed. Now only till now, one application has been now considered by our principal bench. Another application has also been filed, wherein the parties themselves have approached the principal bench and asked that they should be given an opportunity, and they will see that they will examine their case themselves, and they will come back whether they would like to continue with the matter or not. So see the delicacy of the 245. It is so it is like a glass. If you just leave it, it will fall and burst, and it will create a lot of problems. So that kind of very delicate provision it is. At the same time, it gives lot of confidence to the investors, because at every stage now everybody can raise their voice, provided if they form a class, and if they are successful in proving that what has been done is prejudicial to the interest of the company. If they are able to prove that what has been done is not in the best interest of the company and its affairs and its management in the long run, that itself is enough. In a way, simply to say, one ground to establish what has been done is not in the best interest of the company, and if you can convince the tribunal on that count itself, there can be a possibility of getting a notice of admission. So now 245 has a, a new bomb in the hands of, um, say, who's who feels that their rights are deprived, or who feels that the company has been mismanaged. In their hands, 245 is a bomb. If they are able to substantiate the same with adequate documentary as well as other evidences, that is enough. And 245 will automatically come to play. And this class action is in other countries. For us, it is new, but in this judgment itself, they said that our code itself contained jurisprudence class, and no need for an upon because 2000 has combined Fair Companies Act and the insurance the we have entered in the early
I think there's some network problem. So thank you, Mr. Prashad. You have covered the basic judicial insight of this. Sir, Gupta sir. Now, you, Prashad sir, are you? Okay, I will take him later on. Gupta sir. Yes, yeah, Prashad sir. Sir, your voice is breaking, sir.
Am I audible?
Sir, your voice is was breaking earlier. Presently also is breaking.
Now it's clear. Is it clear now?
Yeah,
It's better, sir.
It is better now.
Yes, sir.
Acha.
I think there's some problem with the network of Mr. Prashad. So, Gupta sir, now you are fighting every day with the resolution, with the procedure. And the RPT, the company is getting, the promoters are getting something undue and taking undue advantage at the cost of minority shareholder because you people represent minority shareholder. Now, question is that 245 is now, it is a, it was there, but nobody has raised, it has not come to the test of judicial scrutiny, and now it has come out. When I was a student and I was, when we were writing the book on Companies Act, then 245 and 241 and 244, we were always thinking that class action suit versus operation mismanagement, what is the main difference? Is it not the same? It is not the same issues because class action suit you are asking damage, and in operation mismanagement you are asking removal of board, removal of director, stopping. But somewhere it is mixing also. Both the things are coming together at so many places. So I just want to understand the whole concept, specifically this one also, and how you see future, that future will take shape and future investor protection will enhance in this way, and how your role will be there because you are also not policing every company. So I'm the investor of the company. I'm watching clearly and I'm filing a case. Will you join? How you will support them? Or you are open to all these type of things after thoroughly reading that whether it's a false filing or it's a qualitative filing and something clearly visible impact or something wrong is happening, and then you are joining. So overall, your view about this 245, proxy advisory role and the future.
Thank you. First of all, my compliments to the member of NCLT who have allowed this petition. Because this is the first time we have seen such things.
Yeah.
And it very clearly shows that the member has applied the mind very clearly despite all attempts by the company to derail the arguments. If you look at the order, if you look at the entire judgment, you find that the company took all possible things to say that this petition is not maintainable. The first they said that why 245, why not 241, why not 242? You are coming in the guise of 245, actually it is 241, 42. Then they said that it is not a direct loss, it is a derivative loss, and they wanted to confuse between derivative and direct. Then they quoted that it is not the people who have filed the case, petitioner, who are the lost. It is the company who has lost. So why they are coming? So they are not affected the party. Then various laws from all over the world were quoted. But the fact remains that company did not deny the transaction. The company never said this transaction has not been done. The company never said the outcome of this transaction, which is being alleged by the investor, is incorrect. So, company tried to do all technical things. And it is at this point, I say, we have a long way to go in our country from implementing the law in the spirit. What happens, and if you remember in the last seminar we had about the system, the securities market system, where it was said that we now need to move to the principle-based legislation rather than the theory-based legislation. So I think even before the securities code coming into being, this NCLT has applied the principle-based approach to this. It is high time we move from that and we realize that what is the fact, what is the outcome. And in this particular case, if this petition is to be moved only on the technicalities, on the language and what happened in US, what happened in UK, probably it will be very difficult for the judge to say, okay, you have suffered. But if it is applied purely on the basis of the outcome, that what has been the outcome of this thing, I think it is an extremely fit case of a class action suit. Now, coming to the larger issue, I have been in this business for almost 14 years, and we have seen dozens and dozens of cases where we as an investor, if I was an investor, would not have liked this thing to done, but it continues to be done, whether it is merger, demerger, related party transaction, or whatever it may be. But because of the fact that in Indian environment, promoters are dominant force because of their shareholding, and I would say lethargy or disinterest or the feeling that what I alone can do, the investors do not take the thing to the final outcome. That is one. The second, it is always a give and take that, okay, I got my 10% return or 15% return on the investment. Why should I go after this? Let me just concentrate on my return. So that again is one of the deterrent for investor to take action. But I only say that in a revolution, just one success is a guiding factor or a clearance of path for making sure that the future is good. So if this class action should succeed, then probably you will see many more investors coming out with other things. But again, we have to be very cautious that not with a drop of hat, you should file a class action. Now coming to the second point, that why it is that the Companies Act which came in 2013, it is after a dozen years that this class action suit has come. Now the answer is very simple. It is extremely difficult to gather 100 petitioners or people who hold 2% equity unless one person itself is having a large equity. And if you see, the institutions generally do not want to get into all this, because if institutions are there, if institutions gather up, then probably you will see more calculation. But I will say the success of this will probably drive a governance to be improved a little bit more. If I say not everything, but probably companies will be more cautious in doing something. Coming back to the judiciary and NCLT and all other agencies, the issue that is always bugging me is very simple. I always say that when a petition comes to a judicial body, judge is bound to treat both of them equal. There is no harm in it. But then problem that happens is our system is such that if I am the person who have cheated and I am already sitting on 100 crore, 200 crore, 1000 crore of money which I have cheated from poor people. My capability to hire or engage a lawyer who has got a stature which judges recognize is much better compared to what my opponent who has lost money. So I am with plus 2000 crore, the other body is minus 2000 crore and they are disintegrated. So they are not together. So if you put those people who to fight, then they will not be having a capability to something. And our system is very much biased in the sense that every judicial member, every court, whether it is High Court or Supreme Court, give precedence to the senior advocate. A senior advocate is listened much more carefully, much more patience, and courts show lot of indulgence towards the senior advocate. Whereas the junior advocates are shouted at, they are not listened. So what happens, even the best possible case starts with a negative bias of being loser. So we feel that in order for judicial system to improve, the distinction of senior or junior advocate must go. Every advocate should be treated blindly as equal, not with the open eye that, oh, here Mr. XYZ or ABC, who was my classmate or who we did bar together. To me, if I am a judge, whether it is a person who is 1 year senior or 40 years senior, they should be same. That I should examine on the merit, not on the status. The moment we attach the status to the argument, obviously the person who is senior, his argument appears to be very, very strong. That is one thing. Next is this. This success probably will create, and which is again a two-edged sword. What happens? There is no means for consolidation of victims. If I have suffered in a company as an investor, I do not have wherewithal to contact 10,000 investors and join together, because neither I have their address or data, nor I have got money, nor I have got time. So success of this thing probably will create some sort of a body or agency which, if they feel that it is the right thing, they will coordinate and create a mass of such investors who would be interested in class action suit. In US, etc., there are people who do this type of work, but in India it is not there. But again, everything has a negative also. It could be a blackmailing body also, or some sort of a pressure creating body also, that if you don't do this, I will gather 200 investors and do something. So we will have to be very, very cautious on that. Lastly, I would say, if an investor or 2% shareholder are fighting, they are not fighting for themselves alone. They are fighting for all those minority shareholders, because if a judgment comes in my favor, it will benefit everybody else. Now, I do not have money to fight. So there has to be some sort of a, because there are investor protection funds with SEBI, with the stock exchange, and with mutual fund, with something. So if mutual funds are not able to participate, but at least there should be some guideline from SEBI or something, that if class action suit is filed and on preliminary basis it appears that their grievance is genuine, then legal expenses, etc., may be paid from the investor protection fund. That is what is I would want them to do. And here I will hand over to Pawan.
Thank you very much, sir. Thank you for giving the insight and suggesting that what will happen and how it will take place. Sir, the problem, one very important thing is that investor protection is one important thing, no doubt. But sometimes some scrupulous people are also those who are knowledgeable. Like I came to know that now in the IPO, SME IPO, especially an IPO, there is a professional group. They come out with 34, 30, 45, 50 points and come to blackmail companies. There are so many people, those who are sending, having a one share and sending a list of entire, as per company law, whatever required, whatever a investor can take, they are asking that information. Now, we have to be judicious in this aspects, that somebody should not manipulate this. Every procedural lapse is not a fraud, sir. So how to make it different by like 2%, like in listed company, 2% capital people are there, and they have collectively. The biggest problem is, sir, if you are filing operation mismanagement case, I have not seen any company share falling. But now if you are filing class action suit under 245, you see the reaction, because operation mismanagement cases are multiple in against the listed company, and it is not impacting much. But here it is. And the threshold is also less, 2% for listed company. So I'm just wondering, how will you control this people, those who want to blackmail this, and how you want to cautious, because your role is not only against the company, against this. Your role is the correct, what is good for the investor, you should tell them. Not negative, not positive, but what is right it. So how will you manage this and how will you do this, sir?
Pawan, thank you for elaborating this. I already cautioned that it is not easy, because there would be class of blackmailers also who will mushroom and try to something. See, the problem is this, that when we go ahead with a one right thing, there will be possibility that 10 wrong things will also prop up. It's like a mushroom. That mushroom, one mushroom is of good quality, but 10 mushrooms are of a poisonous nature.
Okay.
So that is always the most difficult part. And probably that is the reason, if you see that none of the operations and mismanagement case has succeeded. Does that mean that there is no operation and mismanagement in the country? There is. But the problem is that system has become such that if I have a problem with you, I come to you directly, blackmail with you, I get my compensation, more than my compensation, and I keep mum. So this type of blackmail has been there, will continue to there, unless until somebody comes forward and say, I am being blackmailed. But then the problem is that very few people will come and support you, because what happens in the market, the reaction does not wait. The moment I release something against a company in a negative, in a biased manner, the investors will take it, because negative news travels much faster and has much more impact than any positive news. So this is a challenge. It will continue to remain a challenge, that how to get rid of the blackmailers from the system. And I would say, if I had a solution, I would have suggested a solution. But then together we will all, the professional will have to work out a solution or guide the regulators or market that how to do it.
Okay. Prashant sir, you that time. So can you just conclude your point, sir? Because we have missed you in between, sir. Prashant sir, are you able to hear me? Okay, I think sir can. Mr. Madan, you are doing practice as a NCLT advocate. You are hearing various cases. You are identifying the issues. So what is your call on this 245? Over to GP Madan.
Thank you, Pawanji. Within 7-8 minutes, I'll reach my office and then I'll join from my laptop. In the meantime, I may start speaking from my mobile when sitting in the car.
Everywhere is the processor also move. You are also on move.
Okay, great. So first of all, before I start my views on 245, मेरी तरफ से and from the, I think, more than a lakh of your webinar viewing community, your fans, your supporters, I wish you a very, very happy birthday.
Thank you.
Oh,
Oh, happy birthday.
Thank you. Thank you. Thank you. Thank you.
And I also give my compliments and congratulate you on you being nominated in the high-powered committee by the Government of India to revamp the Companies Act 2013. You will be providing a yeoman service to the professionals and the corporate sector. So, और आप बर्थडे वाले दिन भी आप ये वेबिनार कर रहे हैं, आपको और आपके जज्बे दोनों को सलाम.
ठीक.
Coming to this class action, I think to Gupta sir को सुनने के बाद ना nobody can dare to speak anything. You know, class action, though under Companies Act, it's a new thing because only on 5th of February 2026, an order has been passed by Honorable National Company Law Tribunal just on the maintainability of the petition. Nothing more than that. So I'll restrict myself to whatever is there in that order. I'll restrict myself to whatever is in the statute book. I'll restrict myself on whatever is there available in the public forum. I will not comment on the merits of the case. I will not give my observation on the merits of the case because those merits are yet to be decided by Honorable National Company Law Tribunal. I think Mr. Prasad agrees with me.
Yes.
You know, in India, the class action suits we have seen in the past also not under Companies Act, but under various environmental laws, under the current data privacy law, under labor laws when the labor rights have been, there have been fights on for the labor rights. In the financial services sector, we have seen, maybe in the capital market also, we have seen where the certain promoters of the companies, they have been debarred, particularly in case of IPO bungling cases. They have been debarred from entering the capital market or accessing the capital market. Under Consumer Protection Act, we have seen various class action suits. And under IBC also, it's very common when we say that in a real estate matter, not less than 100 allottees or not less than 1/10 of the total number of allottees only can prefer an application under Section 7 of the code against the real estate builder. I think that's also class action suit. Because unless the class meets and class agrees to file a petition, this petition is not maintainable. But under Companies Act, we have seen first time that the only maintainability has been decided, and for NCLT, it has taken more than 1.5 years to decide this issue, whether his application is maintainable or not. And I tell you, for all those who are not aware, that this maintainability order has also been challenged in the Supreme Court, in the National Company Law Appellate Tribunal.
National Company Law Tribunal.
5 different dates the hearing has already happened. On 9th February, 10th February, 11th February, 12th February and 13th February. 5 दिन एनस्क्लैट की ट्रिब्यूनल में सिर्फ यही मैटर सुना गया, अपील अगेंस्ट मेंटेनेबिलिटी. और जैसा गुप्ता साहब ने कहा कि that seniors are given preference. The same thing happened. I think a whole lot of a number of seniors were available in this appeal. And on 13th, the order was passed that both the parties are directed to file their written statements, written submissions, and the matter was listed again for today, that is 20th of February. What happened today, I'm not aware. Maybe after the end of this webinar, I'll be able to know it. And the last order which was passed in the tribunal was, the direction was sought from the National Company Law Appellate Tribunal whether this notice can be hosted on the website of the company. Court said so far no timelines have been given in the NCLT order. So, and that's all. After the court stopped. So for all practical purposes, the NCLAT has said, please do not publish the notice so far. This is what my understanding is. Now, what has actually happened, Pawanji, in this case? I don't know whether the facts have been discussed in the beginning or not. Please guide me if the facts have been discussed. Pawanji?
Not in detail, but
Pawanji, आप mute पे हैं.
good quantum of
Yes, sir. Yes, Madan.
I was asking whether the facts of the case have been discussed in this
No,
webinar or not.
facts of the case we have not discussed.
Okay. So let me discuss the case, and these facts are from the order only. The facts of the case is that certain allegations by some shareholders who are holding 4.99% shares in the company. Now, 4.99% shares certainly cannot be held by a public shareholder. My reading is it has to be either from the family or from the associates or from the friends. And all these have become the shareholders only in the year.
Gupta ji has some view on this. Sir,
Gupta ji,
unmute.
sir, unmute, please.
Unmute,
Sir.
sir.
Yeah, I would disagree with Mr. Madan that 4.99% cannot be held by individual, because there are individuals who have been holding shares for long in a company. And I know one person who is a friend of mine holds around 2% equity in a company whose market cap is 60,000 crore. So that is not through anything, it's a direct holding. So let us not put any allegation on anything unless we have full facts.
Sir, I'm not putting any allegation at all. I said this is my observation that in normal circumstances, 3 shareholders cannot hold 5%, do not hold 5% under normal circumstances. Maybe there may be exceptions, but this is what my understanding is. I may be absolutely wrong. I'm not alleging anything. Now, these 3 shareholders who became shareholders in the year 2020, 2021 only, holding 4.99% shares, they have leveled certain allegations on the promoters of the company. That there have been, first of all, certain allotment of shares to associate company, of sale of CCPS, some RPS. I mean, all preference shares, some convertible, some redeemable. The allotment of those preference shares has been there. Later on, certain loans are also. And later on, you know, all these CCPS and RPS, they were sold to one trust which is held by the promoters at 10% of the issue value. And here the allegation is that this is a clear-cut violation of Regulation 23 of LODR. No doubt this allegation has been levied, it is yet to be proved, but the allegation is there as per the facts in the order. Then there is another allegation that certain loans have been advanced to one of the associate companies, Jindal India Power, of 90 crores rupees under a power purchase agreement. Later on, that power purchase agreement is not implemented. This advance becomes a loan. And after that, on this premise that the company to which the loan is given, that company is not performing well, this entire loan along with the interest on the loan is written off in the books of the lender company, that is a listed company. So likewise, there are many other allegations that the funds of the company have been siphoned off from the company in favor of the related parties. So first of all, now the question comes, did all these related parties transactions were approved by the board and might have been approved by the board, but certainly have gone to the audit committee. Now, what audit committee has done at that point of time? God forbid if all these allegations are proved later on, Pawanji, my apprehension is that there may be questions on the role of independent directors who was there on this audit committee. Because all these are related party transactions. There's no doubt about that.
It will come, Madan, it will come.
The total loss which has been estimated as per the audit done, which was done, I think, at the behest of the applicants, is not clear from the order, but some audit is done. It is said there that total estimated loss is to the tune of 2,500 crores to the company. And as they are saying to the company, that certainly this amount belongs to not only to the company, but to company shareholders also. Now, the reliefs which have been sought in this case are manifold. First of all, to declare all these transactions of issuance of shares or sale of shares or loan transaction or writing of loans as null and void. Another relief which has been sought, compensation for these alleged losses this compensation is not there in 241, 242, but compensation there in 245. Another prayer is some restraint orders against the directors of the company. And interestingly, one prayer which is there to initiate disciplinary action against the independent valuer who has valued these transactions or who has valued the sale and purchase of shares, at which value these shares are, so this preference shares can be transferred. Now, first time I'm seeing, my practical experience is very limited. First time I'm seeing that the definition of expert is come into consideration, because the value, as per the definition of expert under Companies Act, a chartered accountant, a company secretary, a cost accountant, a valuer, or an engineer, or any other professional who has the authority to issue a certificate under any law for the timing in force is an expert. Now, why all these are within the definition of experts? All these are under definition of expert because they have the authority to issue a certificate. And if tomorrow anything found to be untrue in this certificate, tomorrow anything is found to be concealed in this certificate, tomorrow anything which is wrongly mentioned or undervalued, all these experts can be taken to task. So in this case, the valuer, the prayer has been there to initiate disciplinary action against the valuer also. I think this particular prayer, tomorrow if it's proved, it may act as a deterrence to the wrongdoers who actually simply work at the behest of the promoters and issue any certificate. And one more thing I would like to highlight here is that under 241, you seek prayer against the company as well as the directors. But under 245, and it's a class action suit, you may ask the reliefs not only from the directors, the senior management, but also from the consultants and advisors also, from the auditors also, from the audit firm also. And same is the case here also, because there have been allegations in this case that the company secretary of the company did not provide support to the applicant, did not give answers to the questions raised by the applicants. You know, the company secretary was asked certain questions with respect to this issue of shares and the valuation and all that. And as per this order, what answer was given by the company secretary to these applicants? That you can raise these questions at the AGM. It means in between, the shareholders of the company are not entitled to ask any question. And another thing which is surprising in this case is, I don't know whether it's a coincidence or deliberate, that the company secretary of the company resigns from the company on 9th of November 2025 with immediate effect. Whether a KMP should resign, can resign, yes, but should resign with immediate effect without handing over the charge, I have my own reservations on that. Gupta sir kenge there is nothing wrong. Maybe I say there is nothing wrong with that. What I'll say, I don't agree with that. A KMP should resign with immediate effect.
Madan, Gupta sir will revert back to you when you will go in your office. Gupta sir will revert.
Okay. Okay, मैं 2 से 2.5 मिनट में पहुंच रहा हूं मैं. Everywhere there's the traffic in Delhi nowadays. Now, what are the contentions of the parties? First of all, contentions of the petitioners. No, because not petitioners, because when the application was preferred, first of all, respondents came forward and they said, no, this application is not maintainable. Because these petitioners do not meet the criteria of section 241, 242, so they have not been able to file a petition there. So they have preferred a petition under section 245. It is not a class action suit. It is an individual's case. This is what respondents have said. They have said this petition is not maintainable. It's a derivative action seeking relief for the company and not for class of shareholders. Because in 245, you can seek relief only for the shareholders and for the deposit holders. There is no third person in 245 who can seek the relief for whom the relief can be sought. But they are saying here in this 245 petition, you are seeking relief for the company and not for the shareholders. There's a major distinction between these two. The respondents are saying, who responded in this case? The first respondent is company, and there are other 15, 16 more respondents who are the directors and company secretary and the valuer and other individuals. The respondent is saying this is not the intent of class action proceedings to initiate an action like this. They are saying petitioners are attempting to circumvent threshold of 241, 242. And also they are saying that 245 is preventive in nature and does not cover past and concluding transactions. Why they are saying this? Because in 241, 242, what you have to say that where the affairs of the company have been run in a manner prejudicial to the interest of the company or public interest, have been run or are being run. But in 245, they are saying where the affairs of the company have been run is not there. So the respondents are saying 241, 242 covers past transactions also because it uses the word have been run, while in 245 have been run is not there, only are being run is there, so only present transactions are covered. So this Honorable NCLT have given an answer that once you see compensation or damages cannot be sought or not being sought for the present actions. Compensation or damages are being sought for the previous actions. So that even though have been run is not there in 245, but have been there is inherent part of 245. Therefore, past actions and past transactions are also covered. Now, what petitioners are saying? Petitioners are saying that the criteria under 245 of shareholding and Rule 84 both stand satisfied. Actually, Rule 84 which talks about the different thresholds. It also says that 245 allows wide range of reliefs, including compensation and damages. And then what the petitioners are saying, that respondents are talking about, that petitioners are trying to bring US law into India, but that is not our intention. Our Indian law is comprehensive enough. We are not importing US law. We are just trying to apply Indian law only. Now, after listening to both the parties, I will come to the other details later on. After listening to both the parties, what NCLT has decided in this case, that the major requirement of Section 245 is that the applicant must demonstrate before the end court that they have formed an opinion on the basis of the facts and circumstances, on the basis of the actions and happening in the company. Opinion, and they have to demonstrate they form an opinion. The court should be satisfied that their whatever opinion they have formed, that is perfectly fine. Here the court has agreed with the petitioners, and court that we find that this petition premises satisfy the requirement section 245 and the prima facie opinion by the petitioners, and they have been able to establish that certainly there might be something wrong. There might be that this siphoning of the money may be there. We are not commenting. The court says we are not commenting on the merits of the allegation. But yes, this petition is maintainable. So that extent the court has decided. I'll stop here. I would like to listen to others on these facts, and then I'll join in 2-3 minutes.
Madan sir, thank you. Gupta ji, whatever Madan has said, you can react. And Prashad sir, I was just wondering, you were concluding something. So now you are in the range. So can you just conclude your point? Then I'll ask Gupta ji. And then
See, what I'm trying to say is that the law is. Are you able to hear me?
Yes, sir. Yes, sir.
The law is not yet settled unless NCLAT gives a finding at the first level and no appeal is preferred before the Supreme Court. Only we that the law on otherwise comes to square one. So let us not think that of 245 has already started, but it only has to write and it has to get done flyover. Now the of is very
Pawan, you're on mute.
Gupta sir, what Madan was saying, can you just raise
Yeah.
some? Yeah.
Okay. See, I heard Mr. Madan and he got into the facts of the case which we did not go it through or something. Now, I have got couple of points what Mr. Madan says. Technically, he is right, but then we have to interpret things in a larger thing because what is the intent of the law that I have said. Now, one thing he said that 245 is something for which is for the continuing or non-continuing issue. The issue is this, that if a fraud has taken place, if the money has gone out of the company, then impact of that transaction on the shareholder is a continuing impact. Till such time that money comes back to the company, the impact will not be over. So that is my answer to whether the transaction is continuing or not. So it is continuing. The second thing, the section very clearly says, because Madan was saying that 245 is only for the compensation to the members of the company. But if you read the section, it says, if they are of the opinion that the management or conduct of the affairs of the company are being conducted in a manner prejudicial to the interest of the company or its members or depositors. So if it is prejudicial to the company itself, that is also included in section 245 for the simple reason, if it is prejudicial to the company, it is prejudicial to the member also. So these are the two main issues which Mr. Madan was saying, but then I will come on the other issues. I totally agree with this fact that it is a test case and will be dependent on many issues. But what I have seen, because this case had come to me even before it was being filed to this, a friend of mine had sent this to me. I had gone through the case and I found that it is a prima facie case of mismanagement or cheating. But since we at SER do not target a company, and this company was not in our coverage, we said we cannot issue any report on that. But the fact is that it will be judicial scrutiny about what is the arguments on side 1, side 2. In my opinion, fundamentally, if I go through the real thing, yes, there is a loss, there is some sort of a cheating by the promoters using their majority, transferring the resources of the company at a throwaway price to the other company. The test would be whether the judicial authority are able to pierce through this transaction and find that it is prejudicial or not. That we will have to see. Next thing that what Mr. Madan said, that if this is found to be true, if this allegation is found to be true, then action could be initiated against auditor, company secretary, the board, and the valuer. I am saying yes, it must be. Even if the law would not provide, it should be done because they are the people on whose opinion entire transactions take place. If they are the people who are misguiding and who are hand in gloves with the management and causing loss to the shareholder, they should be proceeded against. There should be not something. But again, I would say it is too early for us to say it is going to be a successful case or not, because a lot depends, or as we say that there is a lot many strips between the cup and the lip, and it is that situation.
Okay. Okay. Madan sir, can you conclude it?
अभी से conclusion कहाँ? अभी तो discussion और नहीं है. Are you going to conclude?
Okay. Okay. Okay.
What I am apprehending is, because if we come to the penal provision, the 245 penal provision is given somewhere in 245 only.
Mhm.
But according to me, if all these allegations, some of these allegations are proved, there may be a possibility that NCLT may refer this matter to Ministry of Corporate Affairs for further investigation. And if this matter goes to MCA for investigation, you never know if this matter goes to SFIO also. I mean, simply this maintainability order has jittered the professionals, if you ask me. Because the action is being proposed, as Gupta has also highlighted, action is being proposed against various professionals also. Now, गुप्ता सर मैं एक चीज आपसे पूछना चाहूंगा प्लीज you think such class actions suits or class actions should be there in India, and are we ready for this? Because sir, class action we have borrowed from US or other European countries. In US, litigation funding is available, which in India it's not there. In US, the lawyers can charge on success fee basis, which is not allowed in India. So first of all, only those lawyers, those litigants or those shareholders or stakeholders can come forward who have big pockets, who have the capacity to engage, as you said, sir, senior advocates. Because funding is not there, success fee is not there. And you never know whether if success is not there, if the matter is not in your favor, why to waste all this money? And this is, I think, one of the reasons that this class action has not become effective, has not been initiated so far in our country. And sir, as you said, whether SEBI and MCA should not come forward, thus an investor education fund or investor protection fund can be used judiciously for the purpose of class action suits.
Boss, I have already said that the fact remains that I, as a litigant, feel that what are my chances of success? And when I see that opposite me, there will be a lawyer like Madan sir who will be opposing my case, I will say, okay, I don't want to fight because I will not be able to match the capability of Mr. Madan. So that is there. So that is why some funding is there. Now the issue is this: why it is successful in US, why it is not successful in India? There are not one factor, there are multiple factors. The multiple factors is this. First, in US, the judicial system is a little different from ours. We get into comma, full stop, hypercolon, and all other things, something like, and get lost into this. And we can debate what is the meaning of if for ages for 30 years, it still doesn't come to an answer. So by the time the litigant is dead or something is there, so it becomes a problem. So unless until we improve our judicial system to a faster mode, probably many successes will not be there. That is one. The second most important thing, as I said, it is powerful versus less powerful. In judicial system in India, out of 100 cases, 99 cases you will find it is the powerful who is the victorious. It is not the less powerful. Forget about small cases, but all big cases, it is the powerful. I was very much surprised a couple of days back when the Supreme Court said there should not be bail for financial crime. They cannot be treated that non with bail, not jail, for a heinous financial crime. And that is what I have been crying for long, that in financial crime, you do not know who is your victim. There could be hundreds of victims whom you have caused utter misery, but you don't know they are nameless. Third important thing, as I said, very simply, as Pawan also raised, intention. I may not have intention of really filing a class action suit, but I want to blackmail you. How to get rid of those blackmailers from the system? And if tomorrow a funding is started, it may end up that I am funding a blackmailer. It could happen that I am furthering the cause of a blackmailer, because then I may withdraw the suit after I have settled the matter. So all these challenges will remain. But again, I would say there will be one day, one case which will change the whole canvas. And I want that this case should be one such case which will change the canvas of our judicial system, how it operates. Let us hope that.
Gupta sir, just 1 minute I'll tell. If we can make that type of system where the person who is creating a false information or reporting false or filing a wrong case, okay, then he should also penalize. But the problem is that it's a matter of judgment, that I'm saying this company has done this, the company has done this. So the identifying whether it's doing wrong thing or right thing, it's a very thin line. You have raised very right point, but some protection should also be there. And we will
Pawan, I 100% agree with you. I will tell you, in India, the problem is a certified wrongdoer doesn't suffer.
yeah.
You will realize that there was a case, I will not name the person, who had submitted, the lady had submitted the false affidavit on behalf of a person in Supreme Court, and Supreme Court ordered the case to be filed against that lady. And that lady, when she was being issued notice of arrest something, the matter went to the Supreme Court, and Supreme Court was opened in the midnight to help her. On one hand, Supreme Court had said that action should be taken. When the action was taken, Supreme Court opened in the midnight. So that is the problem with our judicial system.
गुप्ता सर, एक चीज और मैं कहूंगा इसमें. Do you think this case may lead to shareholders' activism? And is there any thin line between shareholders' activism and protection of minority shareholder rights?
आप बॉस, आप तो बिल्कुल यूनिवर्सल सवाल पूछ रहे हो. यू आर आस्किंग सच ए यूनिवर्सल एंड डिफिकल्ट क्वेश्चन. See, shareholder activism has two connotations. One is that I am a habitual litigant or habitual activist and झंडा लेके जहां मर्जी आए खड़ा हो गया. I don't want that in life, because then the working of companies and corporations would become extremely difficult, because every other day there will be some activist and somebody will say something, and there will be one person writing against you and there will be 10 newspapers. So we don't want that activist. We want the educated investors who would really do things which are justified. That is why I say the best suited people are mutual funds or insurance companies, but they will never come forward for many reasons. One, they will say, why waste my energy in a company? I will exit that company rather than investing my 10-member team in fighting a case where I'm uncertain, and since I'm holding the shares in that company, I'm hurting my own interest and my interest of my unit holder. Say, for example, tomorrow a mutual fund holds 3% equity or 5% equity in a company, and it files a case against that company. Immediately the price of that share will go down. The price of share will go down. You are hurting the investor who have put the money. So there will be double questions on you. That first, you are holding the money, you invested using your wisdom. So that means your wisdom, your decision was wrong to invest in the company. So these are the all repercussions which stop from institutional investor in filing a case. Unless until the maturity comes of that order, that I don't blame you for investing in Satyam when Satyam was good. Because in retrospect, everybody is intelligent. When the Satyam scandal would have happened, next day everybody will be blaming investor, why the hell you invested. 5 days before, when the Satyam was going up 30-40% over a year, every investor was happy. So all these immature reactions are the biggest bottleneck in success of real issues. I would, as a mutual fund, I will sell the shares and keep at home because I don't want all these problems.
Pradhan sir, Pradhan.
Yes, one more observation, sir. Why so far proxy advisory firms' reports have not been able to instigate the institutional investor or mutual fund investors to initiate this class action suits wherever it was required.
No, that is precisely I explained to you. If my report says something really very, very bad, extremely bad, you as a mutual fund will exit. You will not wait for your investment to become zero, and you also invest your energy, time, and money in filing a case. That is the problem. Otherwise, everybody will say, because what happens? Even the trustees of the mutual fund start questioning you that why, what was the reason for you to invest. Now, remember, human behavior is such that I will not take into account your 20 successes that you have given me 20% return. But in one share, if you have given me minus 100%, I will hold your neck. That is the problem.
Madan sir, you have one more speaker is there, and we have some question answer.
No, please, I
No, no. So
I would prefer question answer.
No, you conclude your point. So then I will ask Ravi and then question answer.
I would like to hear from Dr. Prasad whether he discussed the Unitech case which he was handling as a judicial member in NCLT.
No, we have not discussed about the Unitech.
Mr. Prasad, Dr. Prasad, you are on mute. Please unmute.
He's traveling, so he's.
Dr. Prasad, can you hear me?
Sir, you have to unmute Prasad.
Now, I think you are able to hear me now?
Yes, sir. Yes, sir.
See, as far as the Unitech is concerned, the depositors have approached NCLT with a large number of applications. And those applications have been placed before me. And at that time, we have do not really applied 245. The criteria laid down in 245 is taken into account. And while examining whether the depositor's interest is being jeopardized or not, and whether the organization is acting detrimental to the interest of the depositors or not. And finally, we have given the order for return of the deposits as well as with interest and compensation. Of course, finally, it has gone to Supreme Court. Supreme Court has appointed a committee and the committee is looking into it now. So, the 245 principle was almost all when we dealt with oppression and mismanagement also. We used to study the beginning of the chapter and see till the end. And while studying it, we used to appreciate the framers' thinking, how the law has been developed. And 245 we did not really apply in those days because it has, in 2016 only it has come into force and none of the concrete application has been placed before us. Only in 2018 an application has come, and that being the first matter, it has been allotted to the principal bench, for which you got the admission notice now. So in fact, the principles of 245 have been often looked by all the judicial members and the technical members while looking into the oppression and mismanagement also. What are the scheme of the act and framing and the rationale of various provisions. In fact, the notes on clauses makes it very clear that the object and purpose of 245 is not only to promote investments in India, but also to protect the investors and also investors' interest, and also for achieving better corporate governance. So, Madanji, this is my view, and kindly take further the matter from your end.
Madan, what I can do, I just listen to Ravi and then I will start question answer. Ravi,
Right.
your views and specifically the difference of 245 and 241 and 254 and your own view on this class action suit.
Sure, sir. Thank you so much. The canvas on which Madan sir, Gupta sir, and Prasad sir has painted the discussion today, this particular issue, in light of that broad discussion, looks like a grain of the sand, because that discussion is overarching and that really talks about issues that may arise in face of this judgment and going forward. But let me just point out, let me start where Madan sir dropped. 241 starts with a language which talks about both past and something that is continuing. 245, on the other hand, if you read, apparently only talks about something which is continuous. You go further and you find that is, it also talks about something preventive, but it's only in subsection 3 and before that in the clause of damages and compensation, clause G of 245 subsection 1, you find some semblance with the past actions or the concluded actions. In fact, 245 subsection 4 and its clause F says where the cause of action is an act or omission that has already occurred. Whether the act or omission could be and in the circumstances would likely be ratified by the company. So therefore, on a holistic reading, the tribunal decided on the maintainability and issued the notice. But the problem is this: our laws and the constitutional ethos are not only about the ends, but they are also about the means. The judgments are not only about their conclusions, they are also about the reasons that they record. Where I feel that the judgment could have offered a better reason is on the point which is reiterated in various paragraphs of the judgment, which says that the notice is being issued on 2 counts. One, there is a prima facie opinion, which is the case set out by the applicant. And second, is the numerical threshold of Rule 84 that Madan sir pointed out. Now, a great deal of arguments is being made at NCLAT that Madan sir has again pointed out, is whether that inquiry of numerical threshold and the prima facie opinion, is it sufficient for something which is extraordinary, and if not a doppelganger to 241, is not a far distant cousin, because you see 241 and 245 both talk about manner prejudicial to public interest, manner prejudicial to member or company or the interest of the company. They both talk about prejudicial acts being conducted in a way that are prejudicial to the company or the members. Well, there are some words here and there in 245 and 241. So what Dr. Prasad is saying, that even for 241 actions, they used to take inspiration from 245, is what is reflected in the language of the statute as well. The procedure might be different, but the powers are wide. In 241, it is a settled law that powers are of widest amplitude because there is a residuary clause in 244, in 242, regarding the powers of the tribunal. 245 also contains in subsection 1, the end clause or the last clause of it also contains a power to grant any other remedy as tribunals deem fit. So therefore, I feel that although the notice based on the allegations and which is laid out conspicuously in the order itself about the related party transactions and how they affect adversely the interest of members, I feel the reasons why the notice has been issued could be the main plank, and I'm sure is the main plank of attack in NCLAT. And we may see a surprise it being turned down if at all the court goes into the aspect of whether the inquiry undertaken for the purpose of issuing notice in a section 245 action could be limited to the opinion propounded by the applicants and the numerical threshold of 2% that they have to comply. Is that sufficient? Is it that binary like IBC? Or is there something else to it? Because the consequences are dire. For a listed company, the notice once issued has to be made public. It's not a privately fought litigation. No other class action for the same cause of action can be filed. So everything has to be consolidated here. And in a class action, what could be challenged is not limited. So therefore, I feel that the reasons only on these two yardsticks could be something that the NCLAT would really get into, and we may see a surprise as well on this 245 landmark action the notice that has been issued. Apart from it, well, theoretically, there could be some fundamental conceptual differences between section 241 to 244 and 245. Is one talks about control abuse within the company's internal governance. The other one, which is 245 class action, is more liability based and preventive in nature. But there could be overarching and overlapping issues between the two. So in my opinion, well, I again reiterate that as the ethos are all about both the means and the ends. So therefore, the reasons might be a little concerning for those who are to decide in NCLAT whether these two parameters are sufficient to issue notice, because the consequences are dire. And then what happens if somebody, as an applicant, says these are my prima facie opinion for initiating a 245 action, and the opponent denies it? Because in this case, why the notice got issued is because there were no denial to the transactions that were being pointed out before the tribunal. But what happens if parties are at dispute onto the very transaction that is as the basis of initiating 245? So that's where I'll drop it. I think it's an ongoing issue and sub judice as well. I will not add fuel to the fire by saying more. But I feel these are some nuances that I look at and find really interesting in following this matter forward.
I'll add one more thing.
Yeah.
That issuance of notice by NCLT is not a small thing. You know, after the issuance of notice, then a public notice is to be issued, inviting others, because that is opt-in and opt-out provision. Inviting others that if somebody wants to join, and that public notice is to be hosted where? On the website of the company, in the newspaper, on NCLT website, on MCA website, on ROC website, on stock exchange website. And this public notice will remain there till this entire case is decided by NCLT. And the final decision in such cases, because in 241, 242, we see it takes 5, 6, 7, 8, 10 years, because even 397, 398 cases were transferred on CLB before NCLT are still pending. Suppose this case also takes 10 years, this public notice will remain on all these websites, causing a great damage to the company. Its issue is share price, its rating, everything.
Okay.
So, I mean, sometimes we say that जिस दिन अगर notice issue हो गया, half case is won. You are victorious. Same is the case here. Issuance of notice is not simply issuance of notice. समझो आधा case आपने जीत लिया. It may actually pressurize the other party to sit across the table and settle the issues.
It will happen, Madan sir. Sir, I have a few questions. So what I'll do, the technical question, if time permits, I will come. I have around 20 questions with me. So I just want, let's try to cover all the questions. Sir, this question on governance and board liability. And Gupta ji and Prasad sir and Madan and Ravi can explain to this. So I will start with Gupta sir. Does the ruling increase personal exposure of independent director?
No, can you come again? I couldn't follow your question.
Sir, these are the questions on governance and board liability.
Yeah.
Does the ruling increase personal exposure to independent directors?
See, first of all, what is the ruling? But here only the admission is there. And I have always been of the issue that independent directors are most of the time people who are crying without any reason.
Okay.
When independent directors are appointed, when I write a CV to a company for appointment as independent director, I write that I am God's gift to the world. I have done 40 years this thing, 40 years that thing, I did this thing. And when I go there, then I say, oh God, give me protection. Give me this insurance, give me that insurance, my responsibility is there. My dear, you were put in there because you said that your expertise. With that logic, if I start my job as a bank teller, so first I should sit on the teller only after I get insurance, I get protection, because the moment I make a 2000 rupees wrong payment, my job is gone, 2000 rupees is recovered from me, and I am unemployable. I had no experience. I never said that I am God's gift to the nation. But independent director saying that I am God's gift to the nation, and then you say you want protection. So
Okay.
I have not bothered. If you are holding that position, enjoy the benefits as well as the problems of that position. You can't say problem is of Pavan and Madan, but benefit is only to J.N. Gupta. No, not that way.
Okay.
I still remember, Gupta sir, I still remember the column which you wrote on Gensol. There you wrote that independent directors are there to protect the interest of the stakeholder, and all the other, the practical aspect is that they themselves are seeking protection.
Yeah.
This is what
Prashant
you
sir,
said.
if NCLT,
Yes.
Prashant sir, this is if NCLT becomes a forum for class-based financial claim, does it have the infrastructure to handle complex valuation traits?
As of now, no. But still, NCLT can take the help of something like amicus curiae mechanism, and definitely can address those issues.
Okay. Madan, if independent valuer is dragged into the class action, will valuation report now become defensive document rather than commercial opinion?
Not defensive document, rather it will be disclosing what are the actual facts. It will not be guided by your employer or your client.
So Madan, the point is, Gupta sir, I want your indulgence also. Today, the valuation report is always discussed as a art or science or whatnot. But the question is that valuation report will be a commercial opinion that I think this is the value of this company. In place of doing this, I'm doing something that whatever valuation report I'm giving, it should have a defense mechanism also.
I'll tell you, Pavan, if I, as a professional, had done my duty without any bias or without any pressure, I will always be able to justify my action.
Hmm.
I will fail only when I have done something which I was not convinced because of a pressure or incentive or something. And I give you a very simple example. We all have studied maths. Now, I am still unable to understand with 7 or 8 different variables, which you can choose percentage here and something. If 4 of us sit together, we will not be able to come to a common number. But valuation report, 2 independent valuers for 8 different variables and everything, they come to the same number to 2 decimal place, which is a mathematical impossibility. So again, I say, and I will give a very simple example. Nowadays, we are seeing valuation reports which are based on a cash flow, discounted cash flow, where nothing in the history is there for the cash flow. I got a company which says that we have a land, we will start this thing, we will start this product or something, and the valuer has, based on the extrapolation of future cash flow of that business which is yet to start, has valued the company. So
Okay.
if that type of thing, they will never pass the muster.
Okay. Ravi, should SEBI and NCLT jurisdiction overlap be clarified for listed company?
this will become a big issue in this case also, because as Madan sir pointed out and is very well apparent from the record, the violations alleged are of LODR regulations as well. Now, if you go to SEBI Act, their scheme also prevent any other tribunal to or court to rope into their jurisdiction. And there, in past, there has been a ruling from Supreme Court in a Section 56 case that NCLTs cannot trespass into the jurisdictional boundaries of SEBI. So surely that issue is also going to arise here, and these two should be separate. How can NCLT determine that an action which falls under the exclusive domain of SEBI, how NCLT can adjudicate it? That will be, one is the adjudication part. Second is curtailing the exclusive jurisdiction of SEBI.
Madan,
This issue has been raised before NCLAT also, that all these transactions in question fall within the SEBI's jurisdiction, and NCLT lacks jurisdiction to entertain these complaints, these issues. I think this will also be decided by NCLAT now.
Madan, if the independent, will this change audit committee document RPT approvals process?
Pardon?
Will this change how audit committee document RPT approvals?
I think this particular document, which is there with the standard which is there, now will be implemented and applied in letter and spirit, and if required, it should be made more robust also.
Okay. Prashad sir, if
हाँ जी।
section, yeah,
बोलिए।
if section 241 is largely preventive and section 245 is partly compensatory, does this blur the preventive punitive distinction in company law?
See, in fact, the purposes are different. That is to take care of, say, individual rights, and this is to take care of a class rights, class action rights. Since the purpose is different, it doesn't overlap. Only what I mean to say is, the class action has to be viewed as independent remedy, and the remedies available under 241 are to be seen from their independent examination angle. So they can't be really club, but there can be always an harmonious construction between two when a clash comes.
Gupta sir, can you tell if today we are talking as a student of company law, we have read that majority versus minority. And sometimes what is happening, commercial decision, majority decision is final when we do merger, amalgamation and other thing. So can a transaction ratified by majority still be challenged under section 245? If yes, what happened to corporate certainty?
See, again, it's a very good question and difficult to answer. But the fact is that anything which is even approved by 100% majority, if there is an element of fraud inherent in it, it can always be challenged and reopened. So whether 90% approved, 95% approved, if there is a fraudulent intent, as Ravi has already pointed out, that in this case, in such cases, SEBI LODR also comes into the picture, all the things. So even if transaction has happened, but if there violation is there, it can always be reopened.
Okay. Madan, there is a very interesting point and two questions are interconnected. Should companies proactively run a section 245 audit annually to identify potential class action exposure, including professional firm, also build class action readiness framework?
My answer is no. Nothing, no separate audit is required. There are so many compliance certificates and audit reports which are already in place. And maybe you can add a column there that there has not been a single action throughout the year by the board or by the management which is oppressive to the minorities.
Okay.
There's one single.
I want to add this. Pawan, you are asking us thing that the company should review that what is the threshold up to which we can commit something wrong, which it doesn't classify into a class action. So there will be no discussion like that.
You are right. You are right. Yeah, Prasad sir.
No, actually there is no such a distinction. The moment something goes wrong, even to the scale of um, point 1%, that can be subject matter of challenge. The
Okay.
days are going to come like that, because once people have agitated in group, the minor issue becomes a major consideration.
Okay. Sir, Prashad sir, could Section 245 evolve into a security style litigation regime like the US?
As of now, we are not comparing ourselves, because even the decision itself makes it clear. We go by our own corporate jurisprudence, but there is a scope for scaling to that extent,
Okay.
because ultimately, no, we follow foreign precedents. If the courts have get convinced by the approach of that, and same will be slowly incorporated into the system.
Okay.
You know, in US, this particular class action has been there in the rule book for decades, has been into practices for decades. Many cases have been filed, many cases have been decided, billions of dollars has been the value of all those cases. In India, it's at the nascent stage, but I'm pretty sure the jurisprudence from the US will definitely be discussed.
Flow into the stream.
Yes,
Yes, will flow into the stream. Though
yes,
not directly, by indirectly.
yes.
Okay. Gupta sir, can class actions should be invoked by private equity or other strategic JV partner with minority holding, that is 25%?
No, coming in, this is a very technical question. You got to go
No,
slowly.
no, sir, percentage wise, no issue because it's a 2% listed, 5%
Yeah.
non-listed. The point is the private equity which has invested in the company and other strategic JV partner, they are not the investor only. They are the person who has done the scrutiny, finalized agreement, putting condition, and JV partner is also doing something and taking advantage of the joint. So whether they can invoke the class action suit.
Yeah. So your question is very simple. Can I sue myself?
Yes.
Okay. So it's a thing that I am the petitioner also and I am the defendant also.
Yeah.
Because if I am on the board and I have not been able to stop something wrong, I cannot sue because I should dissent there and resign and then sue. If I'm continuing, I have no capability of suing myself.
Okay. 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 Sir, Gupta sir, 2, 3 questions related to investor activism. So I'll ask fast because time is short. So I'll just you give answer very shortly. Will institutional investor now coordinate more actively in governance dispute?
I would say it is unlikely, as I explained earlier, because if as an investor, institutional investor, I sue a company, I am first raising question on my ability to identify the governance issue when it is happening. Secondly, I will be putting more loss to my company. That is there.
Okay. Will proxy advisory firm begin recommending class action participation?
No, I cannot speak for others, but I will speak for myself. Probably we will raise all the governance issue, but I will not advise what people should do because it is their individual decision.
So you will not jump into this just other people are doing unless you are scrutinize yourself, sir.
Yeah, we will not.
Okay. Could Section 245 become a tool for hostile activism for pressure tactic? That Madan sir, you can give answers.
Maybe or may not be.
Okay.
I think let the jurisprudence develop. We are still at a very nascent stage.
Okay. Gupta sir, you have given answer, but I'm asking again for a different way. Is there a risk of litigation funding entering Indian corporate disputes by after clause 245?
Again, I am saying any provision, any new facility is always prone to misuse. Now, there are two options. Don't start a facility, or you start a facility, make so many checkpoints, so many speed breakers, and based on experience, create a situation, roadmap where it cannot be. But if you say that it can be stopped 100%, no way. Nothing can be stopped 100%.
Ravi, do you think should board now adopt a class action risk matrix as part of the governance compliance?
Absolutely, it will be a good idea to do so. But how far they'll be able to implement on the ground, that's a different thing, because class action, you can really not take into account all the factors that may lead to a class action suit.
Okay.
Another professional opportunity for the professionals.
Okay, Prasad. Okay. Madan, Prasad, I was asking question from Prasad sir, but if section 245 can reopen past transaction, does that create perpetual uncertainty for corporate decision?
Answer is no. If you have not done anything wrong, why should you worry? And
Okay.
if you have done something wrong, certainly you are always subject to.
Okay. I will ask the same question, Prasad sir, also. Sir, if section
Yeah.
245 can reopen past transactions, does that create perpetual uncertainty for corporate decisions?
See, actually, there is a scope. There is a scope, but if from the beginning the companies are doing diligent business, then they need not worry. And failure to do diligence also puts them into problem. Therefore, companies have to act diligently, and boards have to work diligently. Advisors have to work diligently. This is the hour of due diligence. So, if due diligence is sacrificed,
Okay, Gupta sir, what should be the limitation period logic for class action? Knowledge based or transaction based?
I would say it should be knowledge based, not transaction based, because the
have to work on,
transaction has
companies
happened.
have to work.
Sorry, your voice is breaking, sir. Gupta sir, you complete your question,
Sir,
sir.
mute kar do.
So what I'm saying, it should be transaction, knowledge based, not transaction based, because what happened, because the transaction was hidden, the impact was not known, so I could not have acted. Only when I came to know of this thing, then I have acted. So that's why it should be knowledge based, not transaction based.
Okay.
In this case, also majority of the transactions are more than 10 years old.
But I may just add a short point here. On the knowledge aspect, even the constructive knowledge should be attributed. Knowledge should not be an absolute knowledge, but it should be tested on the anvil of constructive knowledge. Because as Madan sir pointed out, all these transactions are done through either the shareholders' democratic process or the board democracy process. So therefore, constructive knowledge concept should also be applied. As we will see as this jurisprudence develops.
Okay, Ravi, one question. If compensation is ultimately payable to the company, how is not derivative in nature?
So, yes, sir.
Yeah, where exactly does section 245 escape the reflective loss doctrine?
So this conflict between direct action and derivative action, how the NCLT has resolved it and how 245 is different, is that in a pure derivative action, you are not seeking compensation for yourself, but in 245, you can seek compensation for yourself as well.
Okay, very interesting question is coming. I will ask Prasad sir and then JN Gupta sir and Madan, all same question, but Prasad sir, can a petitioner strategically choose section 245 just to avoid higher threshold? Mean 2% for listed company of section is as compared to 244 where is it 10%. Is it not forum engineering or forum shopping?
You are correct. It is a kind of forum shopping. That is where the NCLT takes adequate precaution before even considering issuing of a notice. Only if it is satisfied in all respects that there is something which has gone prejudicial to the interest of the company beyond doubt and beyond its own perception, then only it will go for action under 245. Actually, 245 actions are likely to be discouraged in due course of time. This is what my gut feeling.
Okay.
Otherwise, it will open Pandora of litigation, because when your petition is not admitted in other sections, then you will come under 245.
Gupta sir, same question.
Can you repeat the question? I have forgotten the whole thing. Okay, I understand whether threshold can be used for 241 and 245. Okay, I will say there will always be risk that somebody will try to enter the gate which is not meant for it. That's not the thing. But on the independent thought, in Indian environment, the limit that is envisaged in 241, 242 is such high that it is very, very difficult for that limit to have a cross. For the simple reason, when you have got 70% or 65% or 75% promoters equity and other equity is spread in so many people, having a chunk of 10% people supporting one cause becomes extremely difficult. So I would say when you are in this committee that has been constituted by IICA, recommend that the 241 threshold should be brought down.
Okay. Madan, I'm not asking this question, but same question. If both sections use the phrase prejudicial to the interest of the company, why should a petition not first exhaust section 241, then it should go to 245?
241 says prejudicial to the public interest, prejudicial to the interest of the company and the member or members. While 245 says prejudicial to the interest of the company or the members or deposit holders. So as far as the company is concerned, that is common in both the cases. In 245, public interest is not there. 241, it is there. 241 talks about member or members, while in 245, word member is not there. Because a single individual member cannot file this, because even though he is holding more than 10%, he cannot do this. There has to be a class. So there's a clear distinction between the two.
Ravi.
There is a thin line, but there is a clear-cut distinction.
Ravi.
Now see the missing word public in 245 in context of this fact. A class of investors or shareholders numbering more than 200, if you go and do a issue or allotment to more than 200, it will be a deemed public issue.
Okay.
If you offer it to writ large. So in the essence, impliedly, I feel 245 has the ingredients of public interest embedded in it. And we will see it going forward as the jurisprudence develops. Because someone may argue that the members have invested, these are public money.
Okay, now both the advocate and the people have argued. Now come to the judicial members, ex-member. Prasad sir, what is your opinion on this? Your final word.
See, unless jurisprudence is developed by at least a dozen cases, coming to a conclusion how it is going to be exploited, how it is going to be advantageously used, cannot be predicted today. But for forum shopping, a pretext or the other, by as our Guptaji rightly said, people would like to always enter into the gate which is not there, not authorized to enter, to have access to the remedies. So that scope is there, and according to me, the judiciary has to take a lot of care. That is, NCLT has to think twice, thrice before looking into the satisfaction of the criteria laid down under 245 when an application is filed before them. Because it is like a glass in their hands. If the glass is slipped from their hands, then it will break and create a lot of issues.
Okay.
So I think the judiciary will be very cautious, and the judiciary will not entertain frivolous and fraudulent or preconceived applications for any reason whatsoever. They will discourage it. But this is a good beginning. We have to wait and see.
Okay, last question, Gupta sir. Should, and Madan you can also add, should NCLT evolve a structured test to distinguish derivatives action from class action, or should Parliament clarify this?
At least I would say I am ignorant on this very fine thing, derivative or direct something. I always say I got to read into the intent of the law. I don't want to be confused between what words you use. Let Mr. Madan answer this.
I will say at this stage, no tinkering with the law is required. This matter is not to come to an end at NCLAT. It will go to the Supreme Court the way it is being contested. Let Supreme Court provide some clarity on this entire aspect of class action, and then only if required some amendments to be inserted in the Companies Act. But at this stage, nothing is to be changed.
Okay, sir, to close this, there is a very interesting question has come. Prashant sir, is section 245 a shield for minority protection or the beginning of a structured shareholder litigation culture in India?
According to me, this is for both. You really cannot say this serves only one purpose. This serves both the purposes, provided if it is prudently used.
Okay.
मुझे तो इतना पता है this particular order will bring some more better governance in the corporate sector.
Correct. It will promote a healthy situation in the corporate governance.
Yes, yes. Gupta sir, your view on this?
Now, I always said in the first beginning that this is going to be the test case which will either pave way for future class action suits or shut it for at least a decade.
Okay. Ravi?
It's a shock, but sometimes shocks are good for institutions that have been functioning for centuries and for them to change their ways and mend their ways.
Okay. Thank you. So friends, now we have already exceeded time and it was a good discussion. So as a ritual, we are asking the final comment. So I'll start with Ravi. Your comments and then Madan sir, Gupta sir and Prashant sir, closing comments about this particular topic.
Landmark order, but reasons leave me wanting for more. I think, but in one sense, it's absolutely good and good for everyone, both corporates and investors, that it will clarify the jurisprudence on Section 245. At least the talks have begun, not on academic level, but within the corporate and judicial forums.
Okay, Madan sir. Yeah,
I'll just repeat the same thing only. It is another step. It should prove to be a milestone in the better corporate governance in the Indian corporate sector.
And how you see your practice will establish in this area? How you want to suggest?
I'm not seeing the floods of cases as far as the class action is concerned.
No, for the benefit of junior lawyer like Ravi and other people, what you want to advise on this?
No, but because of this, 241 and 242 cases may be on rise. But again, the problem is of the confidence of the stakeholders in our judicial system, because we do not have infrastructure. It is taking years together to decide a case in 241, 242. And I was telling the other day also, Dr. Prasad, that we need a colloquium for NCLT members on this company law provisions, particularly operation mismanagement.
Okay.
Because majority of our members, I'm sorry to say, are not really aware about this, or how these cases happen, how these cases are to be decided. Because still many of the members in NCLT are of the view that majority must prevail.
Gupta sir.
I'm sorry, in one of the cases last week, I had to say to the bench, if this is the approach, then 241, 242 should go from the statute book. If majority has to prevail.
Okay. Gupta sir.
Yeah, so two things. First of all, I agree with Mr. Madan. Majority need not be right all the time. So majority, if there is a fraud intent, majority cannot prevail. That is one. The second, I will use the good officer of Mr. Prasad to say, convey to NCLT members and your friends in community that the interpretation of the law has to be based on intent, not comma, full stop or para, whatever it may be. That is one. The second thing I would say, that treat the litigant of investor not equal to the litigant of the corporate, because any company, or whether it is SEBI or any regulator or even the group of investors, when they come to you, they are not one litigant. There are thousands or lakhs of beneficiaries behind them. So their status is always different and they are vulnerable. That's why they have come to you.
Yes. Prashant sir, your final comment, sir.
My final comment is that we always go with the intent of law, and we refer to the notes on classes, we refer to the legislative background, we try to study as much as the lawyer will do, we do exercise more than that. And it is the lawyers who would like to read us if, why, a, comma, shall, may. Otherwise, we are ready with the straight away with the intention. But it is these people who pours a new syrup. These lawyers, they come and say, sir, you have not recognized here the if is there. So let us see what is this if, and let us see what is this but. And these people are making if and but and if, so that the spirit of law is not properly appreciated. But still we exercise our own care. We allow them to argue, but always the NCLT judicial members and technical members often discuss together, and wherever the Companies Act, we are more careful because 2013 Companies Act makes every one of us to see the progress of the company to be on limelight. Therefore, whenever any application is filed under Companies Act, we often go into the intent of law, purpose of law, and precedents and the precedential value, and we also see the earlier law, how it is developed. Then only we will come to a conclusion. This is what practically I have done, and Mr. Madan also knows when I was dealing with company law, I had the same approach. So my request for Guptaji and others, kindly don't be the impression that we are more concentrating on if and but. No, we are trying to assimilate the legislative intention, and we try to see, as you also know well, the preamble of law is there to open the minds of the maker. There are circumstances where we have referred to preamble also, whenever the circumstances are needed. So it is not that the judgments are passed based on the language. It is, we have really see the application of law, principles of natural justice, precedential value, and rational and impact. And we also sometimes see what is the business approach of the government as a whole, then pass a decision. So, and it is, see, anything 245 has come recently, and it has seen its force recently, and nothing wrong in conducting some kind of seminars, training programs of various silent provisions of the Companies Act to the members as well as lawyers. See, as you know, well, law is a continuous learning process. However learned you are, you have to every day read law and you find something new in it. I too agree with what Madan said. That is what we are doing through PhD Chamber of Commerce as well as NCLT. We are trying to understand law better. I think, yes, see, this IBC has 10 years old, and NCLT is also more or less 10 years old, and this baby, let it grow. And we require more members and infrastructure facilities, then justice delivery system will be in a different.
Okay.
So my final take is that kindly be of the view that there is a due application of mind, and learning has no boundaries.
Okay. So thank you very much, sir. Thank you, Gupta sir, Prasad sir, Madan, and Ravi. Friends, is it clear that Section 245 is not a dormant section now? It is active, and the pressure on the system will also to clarify threshold, notice mechanism, good faith, derivative, test, scrutiny, damage quantify, interaction with SEBI's regime for listed company, and blah blah. So many things has come. Now, this is not about confrontation. It is about the accountability, if I just summarize this. Now, Guptaji's point of view, if governance is strong, class action will remain rare. If governance weakens, shareholders now have a structured remedy. And the real takeaway for Prashad sir's point of view, better process, better transparency, better discipline, and then better interpretation can also come from the regulator, from the judicial side. Now, in my opinion, this is how we strengthen Indian corporate governance. And the point which Mr. Prasad has said, even after that some scrupulous person is going to the judicial process, then what he has suggested that we just see intention, process, transparency, and all these things, and then we'll take a call, not on the blindly on the basis of that somebody has come and we are taking. So corporate can be assured. But what Guptaji has said, be transparent, be clear, and be process oriented, and things will be all right, and no class action suit will come. But the question which is very, very serious here, that 241 and 4 versus 245, that will be a confusion, and that will be a forum shopping will take more shape, because now the gates are open and flood will automatically come in this shape. So let's see how we can do. Friends, thank you very much. Thanks, Prashad sir, Guptaji, Adhan, for structuring this program, and Ravi for giving this word. Friends, our journey of knowledge sharing will continue, and the commitment is there from the corporate professional side. Madan has already said, my team said, sir, today is a birthday, don't do this. Don't do this program. I said, no, nothing doing. In any case, program will take place. So thanks all my speakers and the participant. The journey of knowledge sharing will continue, and our new webinar, next webinar on 27th February is also on a new interesting topic. That is our 254th webinar on competition law essentials. What every business must know. Competition law is very, very complicated thing, high penalty, high compensation, and we want to discuss, because so many business are doing without realizing that CCI is applicable to them. We want to create that awareness, and the corporate professional is endeavor either do proactive programs or create a awareness program in the corporate world. We don't bother about the number of people. We don't bother about the quality. And because these webinars are available on the YouTube, I have seen the YouTube interaction is becoming more after people search this, because 4 to 6, everybody, this is not convenient for all, but YouTube is convenient 24/7. Till then, thank you very much. We will again meet on 27th February 2026. Thank you very much. And
Wish you again a great time ahead, Pawanji.
thank you,
Thank you. Very, very happy birthday to you.
Thank you very much, sir. Thank you. We are very impressed, Prashad sir, for your knowledge and your spontaneous answer for all questions.